Today we're going to talk about a concept that becomes very important and is quite key to understanding how business operates, which is the idea of agency. Have you guys heard about agency before? So we're going to talk about what agency is, how it links up with the idea of organization in business, especially various types of marketing networks, the role that they play within this, the different forms that it takes, and then what an agent is supposed to do, where they get their authority, what are the boundaries in what they do, and what do you get out of being an agent for somebody. So we're talking about the nature, the types of agents, the duties and rights of the agent, and then what is the key legal information that supports all of this. So after you've gone through this class, hopefully you will know something about agency, so it will make some of the transactions that you get into as you're walking around the place a little bit more easy to understand. There are many things that look like agency, but might not necessarily be, and the language here is a little bit confusing because you get a lot of different things that are relevant to the way that somebody does business, to the way in which they bring their products to market and how they distribute and how they approach their customers that might sound similar to agency but are not necessarily agency relationships. In a nutshell, what is it? An agent is a representative of somebody else. But the key to the relationship is the contractual basis of it. You've learned in the law of contract that when people are negotiating a deal with each other, then you go through all these stages that, the kind of formulaic presentation of it is the idea of offer and acceptance and consideration and intention to create legal relations and all of that stuff. So if all these legal terms or legal requirements are ticked, then you end up in the end with having a contract between two people. And you've also probably heard about the doctrine of privity. Have you guys heard about the doctrine of privity? Say me and this lady here are having a contract together that you'll pay me 50 quid and I will write your essay for you, so you don't have to tire yourself. And then you don't pay me. I've given you the essay, you submitted it, you succeeded not being spotted for plagiarism, well done to you. But you haven't paid me, so then I go to your house and tell your mom, cough up, your kid owes me. Is your mom obligated to pay me? Alternatively, you pay me 50 quid to fix the bike, I do fix the bike, give it back to you, you don't pay me, I turn up at the house and say, hey, I tell your mom, look, your kid owes me 50 for having fixed your bike. Is your mom obligated to give it to me? That should not strike you guys as an unfamiliar concept. Rights and obligations out of a contract attached to the people who are within the contract. How do you know if somebody is party to a contract? Basically, it's consideration. The people who provide consideration are the people who are within the contract. The doctrine of privity is the idea that it's only people within the contract who've got rights and obligations arising out of the contract. So you cannot go to a third party, not part of this contract, and ask them to do stuff on the basis of the contract. If you need to determine how do I know if I'm in a contract, if you're providing consideration, you're in a contract. Meaning that if you're making a promise to the other party that you will do something or provide something that they consider to be of value. Issue that arises with agency is that the agent is an intermediary, is somebody else. When you go into the Apple shop because you want to waste some of your money and you're talking to some dude there in the shop and you order phone, you obviously have not ordered the phone from the dude in the shop, right? Because that could be some random dude that's just sitting there. You order your phone from Apple, the company, who runs the store, assuming that you went to the official store. Right? In any type of deal that you do, you walk into the Vodafone shop and you want a new contract for a mobile phone. Obviously, the deal that you want to have is not with the person who just happened to be in the store at the time. You want your contract to be with Vodafone. But you're talking to the person in there. So the person in there has got some involvement, is acting in some capacity, but they do not become part of the contract. So that person in there, most likely, is acting as an agent of somebody else. So the idea of agency is that you have a representative that brings a contract together between the customer and somebody else that they're representing, and that somebody else is called the principal. So when you're walking into any store and you're talking to the employee in there, you're not trying to do a contractual deal with that particular person you're talking to. You don't want that. You want to do a deal with the shop, with the business that is running this shop. So the person that you're talking to is an agent as an employee. They are an agent of the principal being whoever is running the store. So the person in the Apple store with the tight trousers and the stupid haircut is not there in their personal capacity. They're employees of the store and they're representing Apple. The person in the Vodafone store is not there in their personal capacity. They're representing Vodafone. Or if they aren't, then they need to let you know. So the contract that you're going to have is not with that person. The contract is with the principal. So the idea behind agency then, if you need to kind of nail this down, is that an agent is a person recognized by law as having the power to affect the legal rights of somebody else. So they are authorized to do this. They are authorized to create a contractual relationship between you and the other party. Agency is a relationship, obviously, that has links to the law of contract. Most usually we perceive it in kind of sales situations. Most likely when you're obtaining services, if you're trying to get a new mobile phone contract or broadband or whatever it is, or some sort of subscription service, right? You're going through an agent. Totality of this relationship isn't only reflected in the law of contract, but it's got some other elements as well that make it special. Agency is at its base a fiduciary relationship. You've ever heard of the term fiduciary? In law, you have relationships with people. Why? Either they're based on contract or they're based on something else, right? So usually you have legal obligations that arise out of contract or legal obligations that arise out of tort because you have a duty of care, for instance, that's been breached. But some legal relations, or they're defined by the law of equity. You ever heard of equity? The law of equity, in case you don't remember what it is a separate stream of legal provisions, and it has a separate legal history to the common law. The common law comes from what the courts were deciding on the basis of publicized and available rules. However, because the strict application of the rules sometimes led to injustice, you always had the option. You had the option of going to the king and saying, look, this ain't right. This isn't a fair outcome. Can you do something about this? And the king would go, yeah, right, whatever, fine. This happened again and again and again, and it started to develop a sort of consistent jurisprudence of its own. So the law of equity then became like these kind of ad hoc decisions of the king eventually became a body of law on their own. So the law of equity then creates all of these principles that are primarily concerned about achieving fair outcomes when you're dealing with the application of the rules. At some point, the courts were entitled to look at the two together. So the law of equity and the common law came together, and now they're led by the courts in the same way. They're recognized as different streams of jurisprudence, but they're still equally used at the same time. Now, if you're calling something a fiduciary relationship, it means that this is a relationship that is defined by trust and confidence of the people that are coming together in a way that transcends contractual relationships. Now, contractual relationships are, we agreed to do X, Y, Z, right? And this is the totality of our relationship. Beyond that, I don't care about you. So if our deal is, I fix your bike, you pay me £50, that's it. From the moment I fix your bike, I don't care what you're doing with your life. But if our relationship is defined by the law of equity, then it means that I might have further obligations towards you. Maybe I should be interested not only that you got back the bike repaired, but also that you use it safely. That I've got an interest in your well-being, in your future, in the way that you behave, in the way that you behave towards what I gave you, and so on. So if you're saying that the agency relationship and the link between the principal and the agent is not purely one of having done a deal, but it is a fiduciary relationship, this means that you have higher expectations of agents in what they do. So the agent is not only supposed to do what the principal has authorized them to do, sell iPhones, do mobile phone contracts or whatever it is, but they are supposed to care about the business of the principal. So they have a responsibility that whatever they do promotes the success of the business of the principal, and they need to be aware of things that might be within technically the remit, but it wouldn't be a great idea for the shop if they did this, so they need to be aware of that. If you're talking about fiduciary relationships, if you're talking about the relationships of trust and confidence, it means that you've got this higher expectation who's being the agent to take care of your interests, take care of your business. Why do you need to employ an agent? It could be that very simply you need to get access to the customers, and there's no other way to do that. Many stuff happen online now in the sense that you can interact directly with the business, which is perfectly fine. If the business has got a website that is all automated, if the business is selling you car insurance, for instance, right, and you go on the website automatically generates a quote and gives you an option to purchase. If you go and purchase at that time, no human person is involved. Everything works on the basis of preset rules. It's like if somebody puts in this data, offer them this product at this price, and if this person accepts, it's done. Even the paperwork itself is generated automatically. It's emailed to you. That's it. You never have to talk to anybody. If that's the sort of business that you're in, then you don't really engage. You don't need an agent. The business can engage with the customers straight away. But it could be that you need the interaction of people in order to guide the customer, explain the product, explain the options. Maybe this is the sort of business that people like to see somebody that they're not happy to do automatically, right? And that's why you need a human intervention. And that human intervention creates the necessity to buying stuff on their own. You probably don't want to see people. Buying simple services like signing on to a new mobile phone contract or even various types of insurance products, maybe you don't need to see people. But if you're doing something else like renting a house, then you probably need to go see it. So you probably need somebody to take you there to see it. Or you probably need to send an estate agent to explain what it is that you're getting into. Or maybe the principal who instructed the estate agent has given them this brief. You do need the human intervention for certain stuff. The principal, who's the landlord, probably has instructed the agent, talk to the people. So the principal could have instructed the agent to say, I want you to meet with prospective tenants to make sure that they're okay people, that they don't look like bums and wreck the place, right? So it could be that the desire to have an intermediary, a human intermediary, comes from the customer, or it's coming from the principal. It could be that the product is too complex, and people cannot be trusted to pick automatically. They cannot pick automatically because it needs to be customized. They just don't want to do it because it feels too risky, and you need to be able to talk to somebody. More complex types of insurance products, then perhaps there's no office that you can go to, but you can ring them up and talk about this to make sure that you're getting the right thing for you. Or investment products, for instance. Nobody is going to buy investment products and put their money into something through a purely automated system because they will need to discuss, if we're talking about higher amounts of money, they're going to do with your money. So all of that explains why there's a business need to have agents in certain circumstances and not. But these things are dynamic. I mean, the ideas change. People used to go to a travel agent. I mean, people used to go to travel agents, check what's available, and then book it themselves. Now everybody books everything online. I think that seemed risky to do on your own in the past, now is common practice. So maybe in a few years' time, you're going to be able to rent an apartment without even seeing it because, you're going to be able to do a 3D simulation and see the thing really nicely, and everything's going to happen online, and it's much cheaper to do it that way. So everybody will be happy to do that, but we're not there yet. Okay, fine. So we've discussed the core of the idea of what it means to have an agent. We've discussed what the contracts are meant to be about and who becomes part of this contractual relationship, meaning not the agent, but the customer and the principal. And we've discussed rationale for this. So why it's happening and why is there a need for an agent and what do they do? One of the important things to nail down is the idea that the principal will be liable for the actions of the agent. Because obviously, if the agent is not part of the contractual relationship, then the contract is created between the principal and the customer. And whatever is in that contract, the principal is obligated to perform. Because so far as you are concerned, you have a valid contract with the business, whatever the entity is. So you don't care if the agent negotiating this with you has made a mistake. Yeah? Now, for some of the more complex stuff, maybe the principal needs to double check and give authorization for whatever has been agreed by the agent. But if the deal is different, that the agent has full authorization to complete the deal, if the agent has made a mistake, then they can back to you. Meaning that if the person in the Vodafone shop has made a mistake and is actually giving you a phone for a price that they're not allowed to give because they got confused or whatever, then if you have a valid contract, that's it. The principal cannot come back and say, oh, sorry, this person didn't know what they were doing, or they confused, or they pressed the wrong button on the computer. He's going to be obligated to say, right, now we have a contract, so if I don't want this anymore, I need to check whatever options for cancellation or termination exist within the contract. But they cannot deny the existence of the contract. So this is important for you guys to remember, that the principals will be liable for the acts and omissions of their agent. For things that fall within the agent's authority to do, sometimes even for things that are outside the agent's authority to do, the principal becomes responsible. Sometimes it is obvious that somebody is an agent because their title or their job description or how they represent themselves will make it clear to the customer that they're an agent. So if you walk into a shop and somebody is clearly an employee of the shop or has a label that says customer representative, then you know that you can talk to them about doing a deal with whatever this shop is selling. Other people have got the function of agents as part of their job description, even though they don't turn up in an outfit that identifies them as salespeople for a shop. For instance, company directors by default are the agents of the company. So if you're named as a company director on the information, every company has got its information about who is running it publicly available. So if you check, in X company, who is the director, and you get a name there, if you're dealing with that person, then that person represents the company and you don't have to worry about it. Equally, if you're in a partnership, each partner of the partnership automatically is an agent for all the other partners. Employees will normally be agents of the business if they're in a marketing or sales or something that involves them interacting with the clients. But the mere fact that you're an employee does not automatically make you an agent. So I am an employee of the University of Westminster. This doesn't mean that I can walk down to Tesco's and order sandwiches for everybody on behalf of the university, because I don't have authority to make purchase decisions on behalf of the university. If my authority is not obvious and I do something on behalf of somebody else and there is no reason why they would assume that I'm representing somebody else, then whatever contract has been made is between me and the person that I'm dealing with. So it's important for you to distinguish areas when somebody identifies themselves as an agent of somebody else and then the customer knows that there's a principal with whom they're going to have the contract. Situations where somebody does not really identify themselves in that way, but it's obvious that they're there on behalf of somebody else, like a company director or a partner or a purchasing manager in a business or whatever, and situations where somebody is linked with entity, but then it isn't immediately clear that they've got the authority to represent. I cannot, as an employer, I cannot buy stuff and charge them to the university. But if the university is tasking me with a particular thing, so we're having an event here and we run out of crisps, and the head of school gives me a credit card and says, run down to Tesco and get us some more crisps. When I go there and I present the school credit card, then the way in which I'm paying is going to demonstrate that I'm not buying for myself, I'm buying for somebody else. But there needs to be an additional step that communicates to the other party that I am acting on behalf of somebody else. Otherwise, if it's not obvious, if there's no link, or if there's nothing to suggest that, the danger is that the contract that I'm creating is going to be just between me and the shop. So if for some reason I don't pay or I do something wrong and I'm after somebody, they're going to have to come after me. There are situations where you have a non-obvious, an agency relationship that is not revealed. So you're dealing with somebody, you're the customer, you think that that person is the person who's going to provide the service. It turns out they're an agent for somebody else. But what happens in these cases, so that the customer is not disadvantaged, then both the person who's the agent and the person that they represent, without saying, they both become co-responsible for delivering the service. So if I'm dealing with somebody and I book the service for my car, and when I turn up there, it's actually somebody else, or the garage belongs to somebody else, not the person that I was talking to, and I'm like, oh, what's going on here? I didn't think I had a booking with you guys. Both the agent who did not disclose the relationship and the new person, they both become liable for me to do what we had agreed, right? So in a way, it spreads the responsibility to more people, but in a way that it does not disadvantage the customer. If we go back to this idea of who has authority and who is allowed to present themselves as agents and be recognized as such, your options are actual authority or usual authority. Actual authority is I'm wearing a t-shirt that says I'm an Apple salesman in the Apple store. Usual authority is I don't wear the t-shirt, but I'm there. I'm the person sitting behind the counter. You've done business with me before. You recognize me as working for somebody else. Apparent or ostensible authority is the idea that I am not wearing the t-shirt. You haven't done business with me before, but the circumstances are such that they give the impression that I'm allowed to do this. One of the dangers with this is that it could be that you recognize somebody as having the authority to bind somebody else, but you don't know the limits of that authority. If the limits of the authority are not clear, then again, the emphasis in the law is to protect the customer. So the business is not going to say, oh, hang on a second, this person was authorized to do contracts with you up till that level, but contracts are not going to respect the higher contract because they breached their authority. So as far as you're concerned, you didn't know. So this person was recognized as a representative. You don't know the details. That's why I told you earlier, you can be dealing with an agent and the principal becomes responsible for the actions of the agent, for the things that are directly authorized to do, and sometimes for things going beyond that. But it's a matter of assessing the circumstances and figuring out where to draw the line. Something that's completely random and completely unrelated to the business of the principal, then you cannot pass this on to the principal. But for things that kind of look within matching the flow of what the person is doing, then all these obligations are going to flow up to the principal. But what exactly are the duties of the agent, right? Assuming that somebody comes here and says, would you guys like to become representatives of one of the publishers, so then you can push the textbooks to the rest of the students, right? Would you like to act as an agent for the university press and take orders from them and give the textbooks to your fellow students? What are the duties that you will assume if you accept to act in that position of an agent? The first and primary duty is the idea of having a duty of care and skill. An agent owes the duty to the principal to exercise reasonable care and skill in performing the duties. This has various expressions, both in the law of contract and in the law of tort, but the idea is that you are not negligent or reckless in the performance of your duties. Meaning that you do a contract to students and they have ordered from you, right? When you're delivering the books, it's part of your job to make sure that you give them what they asked for. You don't give them the wrong copy, or you don't give them the wrong edition, or you haven't left them out in the rain to get all wet. You see, you have to perform as you would perform employees about the level at which you're meant to do your work. The same thing applies if you are an agent. I already mentioned that some aspects of how we understand your obligations are the things that come under the label of fiduciary duties. Now, this is equity. You have an equitable obligation to protect the principal from abuses. Not only you need to respect your contractual obligations, but also you need to take care of your agent's interests. If it looks like, for instance, that the customer is not right, there's something wrong about them, they don't look like they're gonna pay, or they look like they're running a scam, it is part of your job not to do the deal with that customer or to take protective measures, for example, to protect the principal from suffering. A lot of what comes into this kind of fairly vague definition of fiduciary duties and equitable obligations might be new to you guys, especially because you haven't spent a lot of time doing that stuff. So when you come across these concepts of what the fiduciary duties are in the textbook, you need to read it a little bit more carefully, because this is likely to be more new to you than the other stuff that you've seen. Some of the other duties are more obvious. The agent is not supposed to find conflicting duties. So if you accept to be an agent for Oxford University Press, and you also accept to be an agent for Pearson, and they both make these textbooks on the same subjects, that they're competing for the same market, are you going to buy your textbook from one brand or the other brand? If you are an agent of both brands at the same time, which one are you going to push when you're trying to sell it to people? So the fact that you have a conflict of interest there, or you have obligations that by necessity don't match, means that you're not doing it as an agent. Yeah? You cannot simply be promoting to the same people two competing products. The one that they choose is okay, but the one that they haven't chosen, you're in breach of your duties to your principal. The agent is not allowed to be in a position of conflicting duties, and also they're not allowed to make a secret profit or to accept bribes. So you cannot go to the person at the Vodafone shop, cannot tell you, look, these are the options if you want the new iPhone, right? But if you slip me 50, I'm gonna put on the computer that you're getting, so I give you the iPhone anyway, nobody's gonna know. That's not right, because in that case, the agent is accepting either a secret profit out of the deal or is accepting a bribe, and they are doing this for their personal interest in violation of the interests of their principal. If the shop was doing this, then obviously not doing a good deal for the brand, the business that they're representing, they're doing a good deal for themselves. So this is not allowed. And you also have a duty to account. So whatever money the agent gets, whatever jobs the agent gets, needs to give an accurate information and accurate representation about this to the principal. So the principal knows how the business is running through this agent. And finally, unless specifically authorized to do this, the agent is not allowed to delegate to other people. So university hiring you to be the agent is probably because they like you for some reason, right? Or you got particular skills or connection. They didn't hire you for you to sit at home and then hire somebody else to go do the job while you never show up. Unless they specifically told you, yes, you're allowed to recruit other people to work for you, then you have an obligation to do the whatever the work is yourself. What are the rights of the agent? Well, if you become an agent for somebody, you're probably not doing it for the glory, but you're doing it for the money. If you accept to work as somebody's agent, you're doing it because you actually are trying to make a living. So the primary right of the agent is to receive payment for the work that they've done. And in order to receive payment, it needs to be specific in the deal that they've got with their principal. What do they need to do in order to get that payment? And they need to be given the opportunity to earn, if they're earning a commission, they need to be given the opportunity to earn that commission. So if you are, people in the Apple store are getting commissions on sales that they make, and that's the deal. The deal is you're on minimum wage, but then you get 2% on every iPhone that you sell. You might think, yeah, all right, that's not a bad deal. But if they stick you in the warehouse, so you never get out to meet any people, then you don't have the chance to make any payments. Therefore, you're not given the opportunity to earn your commission. That would be wrong. That would be a violation of your duties. So if you're hired in order to represent some product, first of all, you need to have access to the clients. You need to be given the opportunity. Where are the clients? Are there numbers you can call? How do you get this information? So you need to have the chance to do this. And this is not kind of good business practice. It is an obligation on the part of the principal to allow you to do this. Now, of course, if you're doing random stuff and you're acting outside the bounds of your authority, then you lose your right to earn a commission. So if you suddenly start selling iPhones at half the price at the random discount that you came up with, and then you turn up and say, oh, I'm so happy I sold hundreds of them, then this is you not doing your job properly, so you have lost your right to earn a commission then. All of that stuff, these rights and these expectations, are expressed in a series of legal documents. A piece of legislation that deals with the rights of agents is this, the Commercial Agents Regulations of 93, statutory document where it contains, in summary, all of these things that you would expect to get as an agent, what you need to do, but also what you expect to get. A lot of that stuff before this legislation were present in the common law, so all these are not new. However, they've been solidified in a statute which is easy to understand. Source of the information, the rights of agents are more secure now after the passage of this legislation than they were in the past when we were only reliant on the common law. Plus, this creates some additional rights about compensation that you have when the relationship is terminated, because one of the problems that you've got with agencies is that it's rather fluid, right? So what happens if you get the agency job, and before you've even had the chance to start, they call you and say, we don't want you to do it anymore. Or if you've started approaching people, you spent money left and right, you're running around here, you're buying coffees for all the students to get to know them so you can kind of start chatting about the textbooks. And while you're doing this, OUP calls you and says, we don't want you anymore. What if all the expenses? What if you're in the middle of doing the deals and then you're cut off? So you would have some expectation of some level of compensation if that happens. This is not quite employment, right? You don't have employment. If you had employment law rights, it would be easier. You don't, because you're not an employee if you're an agent. Not necessarily, right? But still, there needs to be some protection for you when they want to kick you out. Again, that stuff is in the Commercial Agents Regulations, and this goes rights that you used to have in the common law, so this makes things a bit better.